We're incredibly excited and feel kind of pinch me fortunate to have Joyce, author of her book that's in your swag bag, legal commentator, podcaster, former U.S. attorney for the Northern District of Alabama during the Obama administration. She's currently a distinguished professor of practice at the University of Alabama School of Law. She's a fellow at the Brennan Center, and she's a legal analyst, often for MS Now.
So tired.
Author of the very popular Civil Discourse newsletter, which you should all follow. She hosts 2 podcasts, Sisters-in-Law, which I highly recommend. They told me to get a Lola blanket, and I did. So they recommend ads and things. And then she's also on Insider Podcast with Preet Bharara. So we're so fortunate to have Joyce. Maybe a round of applause for Joyce. She's in conversation with Professor Sharmila Murthy, Professor of Law and Public Policy, Faculty Co-Director for the Center for Public Interest, Advocacy and Collaboration at here, Northeastern Law. And she does a lot of writing. She's also, I feel like, in the news some of late. I've seen articles and wonderful other work, but we were so thrilled that she agreed to do this conversation with Joyce. And with that, I turn it over to you all.
Great. Well, good morning, everybody. It is so lovely to be with you today. And thank you to Miel and everyone else for organizing this wonderful conference. And also to Joyce, who, among other things, has a remarkable story, but also, I believe, has some pearls of wisdom and optimism at a particularly difficult moment in time for many of us. But what I'd like to do is actually start with a little bit of your personal story. Tell us a little bit about your career trajectory and how it is that you became the U.S. Attorney for the Northern District of Alabama during the Obama administration.
Well, first, let me start by just thanking you all so much for having me. This is a really exciting room to be in, and I want to echo the comment that was made earlier, that your decision to show up, to listen, to think, to engage in a unique moment like this one in our country's history is incredibly important. And I hope that you will all celebrate yourselves for making that commitment. I think it's something that as Americans we should all be doing right now. I had maybe an unusual path to becoming a U.S. attorney. I had left law school. I went to UVA, wahoo wah. Always good to have a couple wahoos in the room, and went into a pretty traditional corporate litigation practice. My father-in-law was an 11th Circuit judge, and we were very close. He was killed by a mail bomber who was a dissatisfied litigant, and my family was deeply grateful for the way federal prosecutors and the Justice Department handled that prosecution. And ultimately, my husband and I felt like one of us needed to do public service to pay it forward. And it was a good moment for me to do it. So I went to the U.S. Attorney's Office in Birmingham thinking it would be for a year or 2. And I think it was on year 8, I went out to lunch with one of my former partners, and he said, "You're not ever coming back, are you?" And it's, look, I mean, it was an important, just really dignified, exciting moment to get to stand up both in the trial court and in the Court of Appeals and say, "May it please the court, my name is Joyce Vance, and I represent the people of the United States." There is nothing that I will ever do in my career that will equal that moment. And I would include in that becoming a political appointee during the Obama administration, which was a fabulous, fabulous gig. That nothing really, I think, rivals that moment of standing up in court and representing our country and its people.
Wonderful, great. One of the wonderful things about your tote bags is that they contain a book, Giving Up is Unforgivable, a manual for keeping a democracy. And it's a great book. I'm going to talk more about it. But I want to actually start with a topic that's been in the news. You devote in your book an entire chapter to voting rights, which is now at a crisis point. We all know that in Louisiana versus Calais, the U.S. Supreme Court just struck down a voting map in Louisiana on ideological lines. And in the words of Justice Kagan, this gutted Section 2 of the Voting Rights Act. And since that decision, if you've been following the news, you know that states across the South have begun redistricting and redrawing their election districts. So at this moment in time, what should we make of this decision and what should we be doing?
Right, so we're now living through the death of the Voting Rights Act. It's been a long, slow target. Look, I'm an old school voting rights lawyer. I did it before I went to the government. I did it while I was at the Justice Department. I was frequently criticized in the local press for running a plaintiff civil rights shop in my civil division, and I'm proud to own that criticism. And of course, I've continued to do that work since then, because the ugly secret about being a lawyer in Alabama is that if you do voting rights work, it's a full employment plan. And so the history of Calais, which is this gerrymandering case out of Louisiana that the Supreme Court just decided the death knell of Section 2 of the Voting Rights Act, it actually starts in Alabama while I'm the U.S. Attorney when the Supreme Court decides a case called Shelby County versus Holder. In Shelby County, the Supreme Court guts Section 5 of the Voting Rights Act. And you know, Section 5 was important. It was the pre-clearance provision that required states and localities with a history of discrimination to pre-clear changes to their law and practice before they could go into effect. And that was what I loved about it so much. The bad thing didn't get to happen. Section 5 kept the bad thing from ever going into effect. And when Justice Roberts wrote his majority opinion in Shelby County gutting Section 5, he said, "Y'all don't worry, Section 2 is still there." Well, Section 2 was an inferior remedy because it let the bad thing happen. And it was only after the bad thing happened that you could challenge it in court. And it had been mostly used for gerrymandering. But after we lost Section 5, people began to creatively use Section 2 to try to seek additional remedies. And so the litigation continued to narrow our applicability of Section 2. There was a big evolving issue that came to a head in Calais, and this is really what completes the gutting of the Voting Rights Act, about whether it was enough to prove discriminatory impact or whether you had to prove discriminatory intent, which is hard to prove because not every state legislature is as foolhardy as Alabama's, which actually said in Milligan, a case you may have heard about 3 years ago, the Supreme Court forced Alabama to redraw its maps, and that was happening at the preliminary injunction stage. A full trial gets held in Alabama, and the 3-judge panel, with 2 Trump-appointed judges on it, finds, hey, there's evidence that the Alabama legislature intended to discriminate on racial lines. You don't get that too often. We're a special kind of state. I say that lovingly sometimes. But so there's now this trajectory where Section 2, the standard to meet it is so high that it just becomes virtually impossible, unless you're Alabama. I still have some hope for what the Milligan panel might do on remand. You know, that case, Alabama ran straight to the Supreme Court and said, hey, we want to be able to draw discriminatory maps too. And the Supreme Court said, okay, go ahead. But that 3-judge panel, technically that case is on remand to that panel for action consistent with Calais. And I'll just put a little pin down and say I'm waiting for their opinion with bated breath. So what we have here is not a court that has said the Voting Rights Act is unconstitutional. Instead, they've gutted it with the original litigation over Section 5 by invalidating the criteria that was used. now with Section 2 by making the standard unmeetable. And I'm reminded of Ruth Bader Ginsburg's dissent in Shelby County, where she said that curtailing the use of Section 5 was like closing your umbrella during a rainstorm because you hadn't gotten wet yet. You know, in the years since we lost Section 5, people are getting wet. Black voter participation is down, particularly in the South. And that is not because people aren't interested in voting. That's because, for instance, in Alabama, in the wake of Shelby County, we got this crazy Identification Act. And you know, we're seeing that now on a national level with the SAVE Act, which, if implemented either as a law or as some form of executive order, will make it more difficult for Black people, for minorities, for rural people, and for women to vote. Y'all better have your passport and your marriage certificate if you want to be able to vote. And so that's where we are. The umbrella is closed, and we're all getting wet. We're seeing it happen in Southern legislatures, and I think there are plans for it to expand beyond the South. I'm sorry, that was a dissertation. I mean, if you have friends who are not yet paying attention, you know, the right to vote, it's the right that unlocks all of the other rights. And it's not just about a couple of Southern states. It's not just about Black people's voting power being sort of frittered away. It's about all of us, right? When everyone in our communities can't vote, can't participate, it diminishes all of us.
This is a clarion call for holding true to the power of democracy and the power of voting at this moment in time. I want to talk about the special state of Alabama, as you called it, because Alabama actually played an incredibly important role in our nation's history. And I want to say that all of you as Northeastern law grads should be incredibly proud that this past January, a group of students had the opportunity to travel to the Deep South, to travel to Alabama, among other places, with federal judges who organized a trip to study and learn the lessons from the civil rights movement. And you can find some of these details on our website. But it was an incredibly moving experience. And it's incredibly moving at this particular moment in time because we have seen this attack on civil rights and this attack on diversity, equity, and inclusion more broadly. And I'm wondering, at this moment in time, when we look back on the civil rights movement, back on the role that Alabama played, are there any lessons for today that we can draw from the movement from so many decades ago?
So that's a really great question, because I think the important thing to do is not to get so bogged down in despair that we're unable to act. And you know, it's so I'm not a native in Alabama, but I'm married into an Alabama family, and my father-in-law played a pretty significant role in the civil rights movement. And so I've had the opportunity to work not just with leaders of the civil rights movement, but with the foot soldiers, with people who walked across the bridge in Selma, with people in Birmingham who were school children when the children protested and faced Bull Connor and his dogs and the fire hoses. And what you learn from these, you know, it's so hard to explain. These people have gone on to have lives as educators. Many of them, I think, disproportionately are teachers, but as business people, as journalists, as lawyers, just, you know, like everybody else in the world, right? All different fields. And then they sit down and they talk with you about their experience. And the one thing that I have taken away over time is that when you have something really important to do, a real big problem, a societal one to deal with, like democracy being under threat, you do not have to deal with that problem alone. In fact, you shouldn't. You should absolutely deal with it in community. And so I love the fact that we started today with music, because that's something that you learn from the foot soldiers. Always start with music, right? Every movement needs to have an anthem. And we need to be in community, because the risk in a moment like this one, and I'm just not going to put a fine point on it, is you let the depressing overhang suck all the joy out of your life. And the whole point of living in a democracy, in a country that's grounded in the rule of law, is that it allows us to create these rich, full, wonderful lives where we can pursue our interests with a certain baseline of security. And so coming together in community to protect our democracy, but also to celebrate it, to me, that's the lesson that I learned from the civil rights movement.
Let's talk a little bit about communities that you have also created. So as we heard in the introduction, you have co-hosted and started 2 different podcasts. And in particular, I would love to hear a little bit about hashtag Sisters-in-Law. Can you tell us what led you to start that? Who are your co-hosts? And I know that one of your formats is that you invite listeners from the public to share questions. And I would love for you to maybe share one of your favorite questions that you got.
So this is just so much self-indulgence on my part. Hashtag Sisters-in-Law, we are coming up on 5 years, which is sort of crazy. Thank you. It's 3 of my best friends, really, really remarkable women. Jill Wine-Banks was the only woman on the Watergate team at the Justice Department. She's unbelievable. Kim Atkins Storr, a lawyer who's now a journalist. She covered the Supreme Court for many years. She writes for the Boston Globe, so I bet a lot of y'all read her. And then Barb McQuaid, who was my U.S. attorney colleague in Detroit. And Barb and I not only did a lot of work together as U.S. attorneys, we're consistently confused for each other, which befuddles us because we look nothing alike. But my husband actually had the experience of being in an airport in Portland, Maine, of all places, and having somebody run up to me and say, Miss McQuaid, Miss McQuaid. And at this point, I just respond. But so here's the thing. We would sit around in the green room at MSNBC and just have these great conversations before we did television. We were all analysts for MSNBC. And one day, and I just don't remember now who it was, somebody said, you know, you should just do a podcast and sit around and let people hear these fascinating conversations. So that's the conceit for our podcast. We get together on Friday afternoon. There may or may not be alcohol involved for some of us. And we talk about what we think are the most important issues because we have a deep-seated belief that Americans are really smart, that you don't have to have gone to law school to understand the issues that concern us, and that, you know, democracy, it's a participatory sport, and everybody needs to engage.
Great. And do you want to share a favorite story, perhaps, that a listener submitted?
So the questions are great, and if y'all want to ask us questions, you can send them. Let's see if I can do it without thinking. Sisters-in-law@politicon.com. We'll get you a question in our list. So we answer questions every week. We had so many that we've actually started doing a second episode on Wednesdays where we do nothing but answer questions. And so I've got to say, my favorite questions, because I'm sort of boring and nerdy like this, if y'all haven't figured it out already, but I love it when people ask basic questions about how the Constitution is meant to work, because I think those are the questions we need to engage with as Americans. And there's so much misinformation and disinformation surrounding stuff like the First Amendment. What are your rights? You know, when does a president get removed from office under the 25th Amendment? Can you just take birthright citizenship out of the 14th Amendment? So those are the fun, super geeky questions that I always love the most.
Great, thank you. So in your book, you have a lot of memorable quotes, but this one really struck out at me. You wrote, "Courts can break your heart. The same court that can make positive changes once thought near impossible can also extinguish them." And this seems incredibly true on many issues today, but especially true on women's rights. And it's already been 4 years, if you can believe, since Dobbs, when the Supreme Court overruled Roe versus Wade. And currently, the justices are considering whether to allow restrictions on the drug mifepristone. And what should we make of this?
Well, the court sure can break your heart, can it? I think it's important, by the way, to acknowledge what federal district judges across the country are doing. The way that they have stood up, knowing that sometimes the President of the United States takes to social media and puts a target on their backs for doing it, is nothing short of remarkable. And I've talked with many of those judges, and they all say pretty much this: well, that's my job, is what they say. You know, how do you find the courage to do it? My job is to decide cases based on the facts and based on the law, and that doesn't matter which president put them on the bench. And so I offer tribute to those folks every single day. Y'all, when I was on my book tour, one of those judges, we spoke briefly, and they told me that they had received postcards in the mail from people supporting them after a decision that they had made, and they were so touched that they keep them in their desk drawer, and they pulled them out on bat. I mean, federal judges, they're people too. Who knew that? But yeah, so mifepristone. You know, this is round 2. The Supreme Court had a mifepristone case a couple terms ago. They ducked the issue, right? They just said, these plaintiffs don't have standing. And they decided to leave the issue for another day. Because in the wake of Dobbs, mifepristone has really emerged as the issue. And here's why. An overwhelming oh, I'm going to get choked up now. An overwhelming majority of the abortions that American women obtain are medication abortions. And that means mifepristone and another drug named mifepristol. They're prescribed in combination. That's the safest, most painless way to do it. If you believe that there should be a nationwide ban on abortion, mifepristone is interfering with your plans. And so much like those endless assaults on Roe versus Wade, where groups kept putting together cases that were designed to ultimately get a case like Dobbs in front of the Supreme Court for reversal, same thing has been going on with mifepristone. So now there's this new case in front of the Supreme Court, and it goes up on the shadow docket. There's a preliminary injunction out of the Fifth Circuit that would let this really distasteful Louisiana law that's in essence a national ban go into effect. And so that comes to the Supreme Court on the shadow docket. Justice Alito put in a temporary administrative stay, originally for 7 days. He expanded it to 10 days. And that's not surprising. Don't read anything good into it. The Supreme Court almost routinely issues administrative stays while they look at an issue like that. I think the interesting thing is that as of yesterday, right? Today is Friday. So yesterday afternoon, the Supreme Court issued an order that says that mifepristone will remain available while that litigation proceeds. There were 2 dissents. I bet those of you who follow the Supreme Court can guess who the 2 were. But because it was a shadow docket ruling, they're not obligated to write an opinion, nor is the majority explaining its decision. I think Justice Alito addressed it briefly, calling the majority's decision shameful or something along those lines. But mifepristone remains available at least until that case comes to the court on its substantive docket.
Let's turn to another issue that has been facing communities across the U.S. and tearing communities apart, which is the immigration crackdown. And this is something that we have seen. The images are very hard to see, let alone experience. And as a former federal prosecutor, what should we be making at this moment of the immigration crackdown?
Well, you're just full of cheery questions. You know, in 2011, Alabama passed a law. It always goes back to Alabama because we do tend to try out the bad stuff there to see what spaghetti strands will stick to the wall for the rest of the Republican Party. I say that lovingly to my Republican friends. HB 56 was a bill that the Alabama legislature referred to as a deport yourself style law. And it was pretty effective at doing that until we got into court litigating alongside some great partners, friends from the ACLU, the Catholic Church and the Episcopal Church litigated alongside us. We all had standing to bring different claims. And ultimately, first the district court and then the 11th Circuit shut down the most heinous parts of that law. But you know, it was an interesting experience because I had sheriffs and police chiefs who came to me and said, you have got to sue the state. This law is just terrible. It forces us to misallocate our law enforcement priorities. And so I would routinely say, great, will you give me an affidavit that I can file along with my lawsuit? And you know, some of them did, including a couple of elected Republican sheriffs who had the courage to do that. Takes a lot more courage these days to go against the administration on immigration. But it is a moral imperative. And I think we have to all stand up, particularly as lawyers. Elections have consequences. The White House gets to design policy. But to hold people in constitutionally insufficient conditions where babies don't get medical care and the food is full of maggots, that is something that we have to all be standing up against. When a 5-year-old is taken off the streets in Minneapolis and used as bait to lure his parents out, our country should be outraged. And I'll just say, I view this as an issue that we all have personal responsibility for. I was in Maine when ICE surged to Maine. You know, they were in Minneapolis. They tried to do the surge in Maine. And I had the honor of participating in the ACLU's Know Your Rights training. And I'll just tell you what I think exemplifies the kind of commitment that we should all have. In the big training that we did, it was crazy. It was on Zoom with over 1,000 people. A retired federal judge from Brooklyn was doing most of the training, and I was on with him. And I had a school bus driver from northern Maine ask me to walk through with him step by step what was required to be in a warrant before law enforcement could board his school bus. Wow. I have not told this story other than one time because it makes me cry, so I'm just going to apologize in advance. But he walked through with so much detail. This guy who was probably making minimum wage, you know, in Maine, which is a really white state in so many ways, although it now has a big Somali immigrant community in Lewiston in particular and in other parts of the state. And it becomes clear to me while he's asking me questions that this guy is going to put his body between ICE and the kids on his bus. And he wants to know what his legal rights are, but he doesn't really care because he's not going to let them near his kids. That kind of courage, I think, made it very difficult for ICE to sustain what it was trying to do in Maine. And ultimately, Susan Collins played a role in getting them to leave the state, although they are still there, right? And one of the worst problems right now is that ICE is running silent and deep and trying to stay out of the headlines. That's the new approach of their new DHS Secretary, Mark Wayne Mullen. But I think that this is an all-hands-on-deck moment where we have to each do whatever we can, whether that's packing food at a local food bank to go to people who are afraid to go to the grocery store or playing a more formal role as lawyers.
Well, you can see why I'm asking her all these hard questions. It's because at this moment in time, you offer a clarity and you remind us that all of us, in particular in this room, with our law degrees, that we can play a role, that is our duty as members of society and also as card-carrying lawyers to actually help at this moment in time. I want to talk about other courageous people that you profile in your book, where you also found comfort in their words and in their willingness to stand up. So one was Cory Booker, and the other was Angus King. Can you tell us about what words did they share that really gave you hope?
y'all remember when Senator Booker stood up and did that unbelievable filibuster? You know, it's interesting. I wrote about it in the book, I mean, right after it had happened, I think. But I feel like it was a little bit of a turning point moment. That was sort of the moment when we began to believe that we could do something about this administration. And so, you know, it's become popular to criticize the Democratic Party and its leaders, for sure. And I will just say, I'm not so sure that they merit the criticism. I think in a really tough moment, they are developing innovative ways to push back, and they've been able to hold the line against some of the worst excesses. On Saturday, I guess that's tomorrow now, I've lost track of the week, groups like Black Lives Matter have joined forces with, at this point, I think everybody from the civil rights community and groups in civil society have signed on for protests in Montgomery, Alabama and Selma, Alabama over gerrymandering and voting rights in particular. Senator Booker, who was in Birmingham last weekend, is coming back down to be there, joined by, I think, yeah, right? I mean, it's amazing. So I spoke with my Congresswoman, Terry Sewell, who represents Selma, last night. She told me she would be joined by 15 of her House and Senate colleagues, which on like 4 days notice, getting a bunch of members to give up their weekend this close to the midterm elections is pretty crazy. And I think it's a testimony to that movement that Senator Booker has played a big role in inspiring. Angus King, this is one of my favorite stories about voting rights. And I actually called him up and made him tell me the story, which 4 or 5 different people had told me, because I wanted to make sure I had it right. And this is the deal. Y'all know Angus King, right? Because we're in his neck of the woods, Maine's independent senator. So when he was the governor in Maine, he and Jesse Ventura, who was Minnesota's governor at the time, had a standing bet. And their bet was very simple. It was about which state could have higher voter turnout. And they were both committed to that. 2 very unlikely figures, right? I just love this story. And he told me at some point, some of his political folks said to him, you know, Governor, if you make it easy for people to vote, not all those people are going to vote for you. And to me, that story and his commitments, and by the way, Maine is still, and Minnesota both, they're like really high up on the lists of voter turnout because culture matters, leadership matters. Shenna Bellows, who's currently the Secretary of State in Maine, is one of these let me take cookies to the polling places on election day and make sure everything is going as it should and people can vote. Again, you know, somebody who's running for governor figures it's up to her to win the hearts and minds of voters, but just wants to make sure that every American who's eligible to vote can vote. And that seems to me to be the important lesson. Our politicians need to understand this duality. Everybody who's eligible has a right to vote. It should be easy. It is not a privilege. You should not have to jump through hoops. It's a right you should be able to exercise. And then it's up to the politicians to convince you to vote for them. That's the political act. And so I love sort of in tandem Senator Booker and now Senator King and their views on the political process.
Great. I'm going to ask one more question, and then I'm going to go to your question. So if any of you have questions, be thinking about them. So I want to ask a question that actually might make us a little bit uncomfortable in the room, okay? Today, you might actually just be preaching to the choir. So you're talking to a group of educated lawyers who mostly attended a very progressive law school, who live and work in a very progressive state. I spent a number of years living in Nashville, Tennessee, despite being a Northeasterner, and I know that there are real differences across the country. And my question is, are we too insulated? Are we part of the problem? How do we actually bridge this really significant divide in our country that is really both political and cultural?
Yeah. Good question.
Yeah, this is such a great question. You know, I live in Birmingham, Alabama, so you would think that rooms like this would not be my experience. But my neighborhood votes pretty close to 90% blue. We're the University of Alabama at Birmingham neighbor, lots of lawyers, doctors, and you know, it's very much a little bubble. And if I get in my car and drive 10 minutes away, I can see the Confederate flag. So I think when you live inside of a bubble, it's easy to forget. Like I really do. I sometimes forget that the MAGA movement is strong and powerful for people who live just outside of, you know, I live in downtown Birmingham, in that area. For folks who live just outside, it's a very different world. And so even in that proximity, in that state, it's very easy to get sucked into the bubble. And I don't really have a great solution for this problem because I think, frankly, it's the nature of the country that we live in this moment, that we do tend to divide ourselves into bubbles. And I attribute that to the fact that we no longer have shared facts. It used to be that we had shared facts and how you interpreted them. Well, that was up to you, and it was a matter for argument. And that's really no longer the case. My law school roommate, one of my longtime closest friends, is a right-wing Tea Party conservative. And we are lucky that we can still talk about these issues. We disagree. We were disagreeing on social media last night about the Electoral College, of all things. But I think that's becoming increasingly rare. But I still think it's the answer. I think finding spaces that we can engage in, even if it's something as uncomfortable as the family Thanksgiving table, right? I think that we need to remember that disagreement doesn't have to be disagreeable, as trite as that sounds. Because when I look at some of the discourse, I mean, I was thinking about this last week on Twitter, which used to be a place that you could go for information and now is pretty much a cesspool. And I would see comments that were being made or posts that I would make that were just about information. And then they would elicit, presumably from trolls, not from real people, just this sort of foul-languaged use of slurs in response. And that's no way to conduct a democracy. And although I'm definitely not a fan, right, of bringing a glass of lemonade to a gunfight, I think that's the expression. I do think that we have to engage in civil discourse when it comes to these ideas and resist the temptation to end up down in the gutter. And, you know, if people don't want to accept true facts, then I think that's a good place to have the argument and to talk about facts and to explain why they're facts and to ask, you know, well, why are you rejecting that? Well, because I heard it on Fox News. And then you have to dig a little bit deeper. But these are not easy conversations, right? This is always hard. What I will say, the hopeful thing is this. You know, have we been at this for a decade now? I guess it is a decade, right? 2016. I have seen people that I thought would not come back. And the breaking point is different for everybody. You never know when the seeds that you are planting in these conversations will find fertile ground. So it's important to do it, whether it's a conversation in the checkout line at the grocery store or with your best friend. That is our commitment, right? I mean, we're not our grandparents. We're not fighting for democracy on the battlefields in Normandy. We are crazily enough fighting, of course, in the voting booth, but also in the grocery store checkout line and at the family table during holiday dinners, as sort of crazy as that seems.
Yeah.
Great. Well, I would love to go to your questions. And when you ask a question, would love for you to just briefly introduce yourself. Would love to get as many questions as possible. And what almost always happens is we start with a few hands, and then by the end we get a lot of hands. So if you can, try to be brief so we can really get as many questions as we can.
My friend Barb McQuaid always tells people when we do our podcast live, I don't know how she does this, she goes,
I'm a law professor. I will not take your comments, but I will take your questions. Wow. They are really brash. I'm here for the comments. Am I picking? Thank you.
Hi, thank you very much. I love civil discourse. I am not a lawyer, but I'm married to one. I am a longtime activist working to build power, progressive power in state legislatures across the country. And I just wanted to hear your thoughts on continuing that mission now post-Calais, and whether states are going to be able to stand up with their own voting rights acts.
You know, this is such an important question. Everybody gets that gerrymandering only applies to the elections where candidates are running by district. It doesn't apply to your senator or the president. It's just for these district elections. So people think about the House of Representatives, but it also impacts state legislatures. And I'm going to get the state wrong. It's not Georgia, I forget now, but one state has just announced, maybe it is Georgia, that it will be the first state in special session to redistrict not just federal congressional districts, but also state legislative districts. And I've been holding my breath, expecting that that will become the trend and that they will try to gerrymander. You know, in Mississippi, do y'all know Fair Fight, which was started by Stacey Abrams out of Georgia? Fair Fight does tremendous pro-voting work, and they were instrumental in breaking the supermajority lock Republicans had on the Mississippi legislature during the last cycle. Well, now with Calais on the books, Republicans who still control state legislatures can draw those state maps in a way that will dilute Black and Democratic voting power even further. I'm deeply concerned about what we'll see. I know Mark Elias is gearing up to litigate those cases in court.
Let's go to the back.
Thank you. So up until about 7 weeks.
You have to introduce yourself.
Oh, sorry. Hi, I'm Mimi Grigsby. And up until about 7 weeks ago, I was Deputy Chief of Policy for the Cook County State's Attorney's Office. And my question is about, you were talking about ICE agents and what states can do when ICE agents sort of use excessive use of force. A couple of months ago, I think everybody knows that Chicago was in the same position as Minnesota. We had one incident where someone lost their life and several incidents of use of force. And the reason I'm asking is because we had a lot of pressure from community groups and advocates to come up with when prosecutors were going to be able to prosecute ICE agents. But when we were looking at the law and precedent, we were severely limited in what we could do. But we were being asked to do a lot of thinking outside of the box, which was very uncomfortable for lawyers. And I think as someone who kind of sits in both the policy and legislative space, I just wanted to ask your opinion of what a lot of prosecutors are facing, you know, across the country, and it seems like we'll continue to face during this administration.
So I think you're right to identify this as a problem that exists at the intersection of law and policy, or law and politics, because the reality is if state prosecutors charge ICE agents, the federal government will remove those cases to federal court and they will more than likely be dismissed on sovereign immunity grounds. You know, there may be some outliers because some of the conduct committed by ICE agents has been so outrageous. Maybe there's a sliver in some of those cases, like in Minneapolis, that will survive. I think the reality, though, is these are situations that require condemnation and brave action by state and local elected officials. I live in a sanctuary city. My mayor, who's a graduate of one of the HBCUs, the historic Black colleges and universities, is surrounded by a group of advisors who really thought through what it meant to become a sanctuary city and decided that he was willing to pay the freight for that decision. And the community is well educated about what that means. And there's an enormous amount of support for it. Not from everybody, but there are people who believe that other human beings should be able to seek medical care, should be able to maintain a standard of living, that kids under a Supreme Court case called Plyler versus Doe are entitled to a K through 12 education regardless of their immigration status. And so I think it's that civic pressure that we should rely on right now. But I'll just say this. I think that there are some lawyers that are looking at some innovative theories. We will see out of Minneapolis, I believe, prosecution. I think Mary's looking at some innovative ways to do that. Maybe there are some civil cases that can be used. But by and large, immigration is a matter where policy is left up to the federal government, and that makes it a very uncomfortable space for us to litigate in as local and state prosecutors.
Maybe we'll come over here.
I'm thrilled that you're today's speaker. My name is Daryl Every, and I'm a Northeastern law grad, a proud grad. My question to you, Joyce, is recently Trump's Department of Injustice has announced its investigation of the Southern Poverty Law Center. What do you think the real goal is of DOJ's investigation? To shut down Southern law? When I was a law student here, it was one of our co-op opportunities. Is it their goal really to go after the donors and to terrorize them so that Southern poverty doesn't have a source of funds to do its work?
The goal of this prosecution, which is one of the most meritless indictments I've ever seen, rife with just bad information, sloppy in every way, legally deficient. The goal is not just to shut down the Southern Poverty Law Center, it's to shut down civil rights groups and civil society groups who do this work. I'm sure everybody remembers when this administration went after law firms and when it went after universities. And it's now going after civil society, where most of the successful opposition to it is coming from. Why the Southern Poverty Law Center first? Because it's in Montgomery, Alabama, where every active federal judge is a Trump appointee. And it's perceived as I want to say this carefully, district where the U.S. Attorney's Office would be more cooperative than perhaps offices like the Eastern District of Virginia, the Southern District of New York, the District of Minnesota had been. The indictment is utterly shameless. I'm delighted that Abby Lowell, who's an exceptionally fine defense lawyer, has come in to lead the defense. And one not-for-nothing detail of what's going on here is that the donation processors that process donations to the Southern Poverty Law Center and other groups, they have shut down donations to the Southern Poverty Law Center. Right in this moment where people wanted to donate, it became impossible to give through the traditional method. You can still handwrite a check and put it in the mail, which I would encourage you to do if you're so inclined, because the Southern Poverty Law Center does extraordinary work. They do impact litigation, but they also do education. And some of the best education out there in a moment where the administration is trying to rewrite Black history in this country, some of the best quality materials about the civil rights movement, they come out of the Southern Poverty Law Center. So I just view this as a full frontal attack on civil society.
Come. Oh, yeah, right over here.
Good morning. My name is Rhonda Bryant. Wahawa. My question is related to what you just started to talk about. I am a generation removed from Alabama. My father actually was run out of Alabama by the Klan. His brothers were lynched. He barely escaped his life. And so I'm not so old that that's, past history. It's very present for us, for me and my family. So my question is, how do we, as lawyers, help generations, our younger law students, our younger folks, truly get a grasp of how recent that history is, how impactful it still is? And before I became a lawyer, I was a school counselor, I was a K-12 educator, and by the time I left the field, we couldn't teach what we wanted. There were standards, it didn't fit the standards, you couldn't talk about Dr. King a certain way. So I'm curious as to what you think we can do as lawyers to help promote that civic education that our children, even our law students, need. Thank you.
Yeah, so it feels like a semester-long course that you just asked me. Look, I'm a big believer in reforming civics education. And, the whole homeschool movement, I think at least for right now, we need to really homeschool when it comes to civics. I mean, that's for most of our kids where they are going to get access to information. But that's our kids. We're here in the bubble, that we were talking about. And what does that mean for other kids who may not learn about Dr. King? Which, of course, we're the generation where we lived through it. But my kids, when they were in school, they studied and learned about the civil rights movement. And I think that that's slipping away in far too many places. So the answer begins with school boards. MAGA got the jump on the rest of the country and started electing people, putting people onto school boards, controlling curriculum. And I think a big part of the answer is, if you feel passionate about these issues, think about running for a school board. Think about being a voice for restoring common sense to education. And I'll tell you, I had this lovely moment on my book tour. I was in Texas during the off-year election last year. And it was sort of a tough moment in this country to be pushing a message of resistance and don't give up, we can do this. And that sort of changed the week that off-year election happened. And in Houston, they had people in the outlying counties. So I'm doing a book tour and people are coming up to me telling me this story. Well, we tried to do what you were talking about and not give up. And by God, it worked. And they succeeded in replacing some of the worst MAGA members in 3 surrounding counties on school boards. And they were so uplifted by that progress and what it meant that they could do in Texas, of all places. I thought that was very hopeful. And really, if you have the means to run. Or let your local school board members know that you care. For me, teaching the civil rights movement is essential, but of course we also want kids to learn little things like science. In Alabama, I think they're now teaching abstinence. That's what we're taking up public school curriculum with. But in all honesty, figuring out ways to expose not just kids, but adults, right? Because not everybody grew up like you did with an awareness of what the civil rights movement was about. And I think even things like your book club, your church group, your knitting group. My knitting group is a powerful force for social change. Those are the right places to engage people on these issues.
Great. We have time for one more question. Let's go all the way to the back over there.
Dimple, maybe.
Maybe just project.
I'm Chandani. Thank you, Joyce, so much for this. You briefly referred to the law firms, the attacks on law firms, the attacks on universities. I think for me, one of the most surprising things in this time actually has been seeing these elite institutions just quickly acquiesce and comply. And so little discussion of that. So for example, in the public interest sector, people can't get pro bono assistance anymore. And I'm seeing in the philanthropic sector, I'm seeing foundations give money to pay law firms to do work that previously was pro bono. And so I just would love to hear your take on, for those of us that work in the legal community, how do we understand and how do we push back on law firms complying, and what's the work that we need to do to kind of rebuild a culture of pro bono service democracy in the legal sector?
This is an issue on which I think there can't be any compromise. The law firms that bent the knee, that obeyed in advance, you know, some of them did it after Trump issued executive orders that damaged their business. Some of them went in and did it voluntarily to avoid having an executive order issued. And they should be punished. If you have the ability to withhold business from them, do so. If you have the opportunity to speak out against their lack of bravery, do so. I have good friends at some of those law firms. They have left the firms. Some of them, and look, it's complicated when you have clients, right? You can't walk away from a client 2 months before a case that's been heading to trial for 10 years. But literally, the lawyers that I know in these firms are making plans to leave as soon as they can. Many of them, sort of interestingly, and Dimple, to the point of your question, looking to go into pro bono work when they retire from their firms for the lawyers that are late in their careers. So I think we have to just be uncompromising in that regard. The lesson, though, from the law firms that stood up and opposed Trump is that every law firm that has gone to court is winning so far. Yesterday, I think it was yesterday, I've started, the days are running together, either Wednesday or yesterday, there was oral argument in the circuit court, federal circuit court in the District of Columbia. They consolidated those cases together for oral argument. I understand that that went very well for the firms and not so well for the administration. You know, who knows how that one will end up, but I would like to think that very clear First Amendment violations, which is the essence of the Trump executive orders against those law firms, punishing them for representing clients that the administration doesn't like, which just goes to the heart of viewpoint discrimination. I gotta believe even the Supreme Court won't find anything that it likes in those executive orders. And those law firms are brave. I mean, if we had another hour, I would list for you all of the pro bono work that firms like Wilmer are doing, firms like Arnold and Porter are doing every single day, representing, in the case of Arnold and Porter, the New Jersey legislator who was arrested for trying to go into an ICE facility, which of course members of Congress are statutorily entitled to do. You know, my good friend Mark Elias does love to kvetch about the fact that he's no longer getting the support from the private bar to do the election litigation that he does. And he has more election cases across the country than he currently has lawyers in his firm. And so to the extent that anyone works for a firm and has the opportunity to help, I think something that we can do, this wasn't really your question, but I'll just weigh in and say, I think something that you can do if you have the resources is volunteer to work on one of these cases. Or my good friend Norm Eisen, a name some of you may know, who runs Democracy Defenders, which brings lawyers in, files lawsuits on these cases. These organizations that are trying to use the rule of law and the courts to protect democracy are making more progress and providing more of a guardrail against this administration really than anything else that's happening. And so we can support them by talking them up in our communities with financial support or by working alongside of them. But that's what it's going to take to get us through the midterm elections and beyond.
Over the last hour, we have heard some really remarkable insights that really align with the message of today's conference, which is elevate your voice. And I want to really thank you, Joyce, for just giving us really a how-to for how do we elevate our voices, for how do we use our voices to elevate those of others. So please join me in one more round of applause.